and welcome to the second webinar in a series of 3 webinars being brought to you by the DPS. My name's Kath Ogborn and I'm the lead adjudicator here at the DPS. So today we're going to be looking at the dispute and establishing whether or not there has been a breach. So we're going to cover, first of all, we're going to have a little look at the dispute data. You may be surprised actually by how few disputes come through to us. We're then going to have a little look at the 2-stage test that the adjudicator will consider when reviewing whether or not to make a deduction in favour of the landlord from the deposit. We'll look at the burden and standard of proof, evidence versus submissions. We'll have a little think about what evidence might be needed to determine if there is a breach, what the tenant's obligations are, having a think about the condition of the property at the start of the tenancy, also what happened during the tenancy, and then we'll finish off by having a little bit of a think about fair wear and tear. So you may be quite surprised by this slide, but actually the vast majority of deposits are agreed and they don't come through to us as adjudicators at all. So you'll see here 95% of deposits are agreed and there's no dispute. So we're only talking about a tiny number of deposits here, just that 5%. And then this is a slide that shows the sort of the general dispute outcomes. So the biggest section here is this 60% that is a split deduction. So this is basically where a claim will come through to dispute, and actually both parties are a little bit right, and it ends up being sort of somewhere 50-50 between the two parties in terms of how that deposit is split. We'll also see there that 14% of the deposit in a dispute would all go to the landlord, and then 26% of the deposit going to the tenant. You may be looking at that and thinking, oh, that's a little bit unfair that only 14% goes straight through to the landlord and a bigger percentage goes to the tenant. And that's because largely where the burden and standard of proof lies, and we'll talk about that a little bit more as we go along. And here we can just see the different causes of a claim, and I don't suppose it will surprise you very much as landlords and letting agents, but the vast majority of our claims here are cleaning claims. Okay, so ultimately the best disputes are the ones that don't happen. Hopefully you'll have really smooth tenancies and there won't be a need to raise a dispute at the end. If you're thinking of making a deduction from the deposit, though, it's really worth just getting an overview of whether or not that claim is likely to be successful should it come through to dispute, making sure you're keeping those communications open with that tenant and ideally reaching a resolution without it actually having to come through to an adjudicator to look at. Because as you've seen with the stats there, actually it's very likely that the most likely outcome will be that that deposit is going to be split somewhere between what the landlord's saying and what the tenant's saying. So when an adjudicator reviews a dispute, they have to think about this test. There's 2 stages to the test. And first of all, the first thing that they will be thinking about is whether or not there is a breach. If there hasn't been a breach, they're never even going to move on to this second test, which is whether or not the claim is reasonable. So today we're going to be thinking about the breach, and then we'll come on and we'll look at whether or not the second part of that test, whether the amount claimed is reasonable, in our next session. So the first thing to really think about is this burden and standard of proof. And this is the reason why, as we saw in that earlier slide, there's a higher percentage of deposits that will be returned to the tenant than returned to the landlord. I think it was 14% versus something like 26% to the tenant. And that's because ultimately the deposit is the tenant's money. And the landlord, as the person who is bringing the claim, carries that burden of proof to prove that what they're saying and that their claim has merit, that they're entitled to make that deduction from the deposit. So it's always going to be slightly harder for the tenant to prove or to show their entitlement to the deposit than it is for the tenant to show that they're actually not liable for that deduction, because the tenant's not the one that's having to carry that burden of proof of showing that they're not liable. So the landlord will base their judgment against the balance of probabilities, and that basically just means more likely than not. I always like to think about that in percentages. So the landlord needs to sort of show 51% that actually there's merit in the claim against the tenant's much lower burden there. And obviously then if it's 50-50, if you're looking at the evidence thinking, well, anything could have happened here, I consider this evidence as very 50-50, that's not going to be a claim that's supported, that's satisfied that burden on the balance of probability, because we're not quite at that 51%. So this is why it's so important to provide evidence to support a claim. If you're going to be making a claim for the deposit, the first thing that you need to be thinking about is, do I have the evidence that I need to support this claim? Because if you don't, your best option is to try and negotiate an agreement with the tenant. Because if it comes through to adjudication and you don't have the evidence, it's likely that your claim will be unsuccessful. And then what do we mean by evidence, and how are these different from submissions? And this is something that is really important to understand, because a submission is just what you're telling us. So you're telling us that maybe the property was dirty, the tenant returned the property really dirty. That's just your account, that's your opinion. It's not verifiable. Okay, the adjudicator will consider the submissions of the parties and want to understand what the parties are saying about the situation. But that's not going to constitute evidence, and they're not going to make an award just based on a submission. They need evidence, and that's verifiable and factual. It should be objective. That should be something that they can look at, that gives them the information needed for them to assess the facts and to find out exactly what's happened, and to make that comparison to determine that liability. So that's going to be things like your check-in evidence, your check-out evidence, your photographs, your invoices, your receipts, etc. So any admissions, the adjudicator will think about whether or not there are any admissions of liability from the tenant, but these shouldn't be conflated with communications between the parties to try and settle. It's not actually uncommon that a party will make a concession in order to try and settle any dispute much earlier on. So a tenant might say something like, okay, just to bring this to an end, I want most of my deposit back. I'll let you have £200 for cleaning. That's fine, but I want the other £800 back. And they're saying that because they just want to get as much money back as quickly as possible. Not that they necessarily accept that they've done anything wrong. So that's very different from a tenant saying, yeah, actually, I know that the property was really clean when the tenancy started. I know we've left it in a real awful state. I think, yeah, £200 is fair. That's an admission. They're admitting that they've done something wrong. It's not just an offer to settle. If there is just an offer to settle, we will generally be treating those sort of discussions on a without prejudice basis. So they won't form part of the adjudicator's conclusion. So if you joined us in our last session, you will probably already know everything that is on this slide. So this is the sort of evidence that you might need to establish the breach. I won't go into this in too much detail, but do feel free to check back in with that first webinar that we did, which looked at the sort of records that you should be keeping during your tenancy. So we've got the tenancy agreement here, and we spoke about what the obligations are within that tenancy agreement, making sure that they're consistent with legislation and common law. The check-in and check-out reports, the importance of making sure that they're timely, that they're got good detail in them, that they're supported by something verifiable. So that could be photographs, it could be they're independent, could be that they're signed by the tenant. Also our photographs and videos could be really useful to establish a breach. I don't think we really spoke about videos in our last session, so I'll just touch upon that quickly now. A video generally shouldn't really be used as a substitute for check-in and check-out reports. Those documentary check-in and check-out reports are much better ways of making that comparison. Videos, it can be quite difficult because you've got to watch the whole thing through and then find the relevant section in the check-in video to the check-out video to try and make that comparison and determine whether or not there has been a breach. But what a video is really, really good at showing is a moving part. So maybe there's an issue with a blind cord. Maybe it's not working at the end of the tenancy and you're wanting to demonstrate that that blind cord isn't working. So that can be quite useful. And then other evidence there, say your correspondence, your rent statement, your interim reports and your invoices. So what are the tenant and landlord obligations? So when reviewing whether or not there has been a breach, we first need to understand what were the actual obligations of the tenant in the first place. So when reviewing that, you were going to be wanting to think about the following documents. So what written terms were there? That the best place to find those written terms is usually going to be the tenancy agreement. What does that say about the tenant's obligations? Are they consistent with the Tenant Fees Act? Are they going to be enforceable? And also, is it consistent with any statutory or common law obligation? Were there any other agreements that you signed in writing between the parties? A good example of that could be where you've agreed for a tenant to carry out some redecoration during the tenancy. Actually, that might be a breach as far as the tenancy agreement is concerned, but maybe you had a separate agreement there that changed that position. So the first thing you want to be doing is thinking about whether or not this issue is something that falls within one of those tenant obligations in the first place. Because if there is no obligation, there's not going to be a breach. Then start thinking really carefully about the condition of the property at the start and the end of the tenancy. Really carefully consider your documents and be honest with yourself. There's no point being dishonest with yourself here, because ultimately you're just going to end up spending a lot of time trying to make a claim that's going to be or likely to be unsuccessful. So really think about, what does the check-in report say about the condition or the areas of the items? Do the photographs within that report support those comments? Really compare that then with the check-in and check-out condition and think about, has there really been a deterioration here? Or actually, was this issue already present at the start of the tenancy, or was it already starting? Was there already a bit of an issue there? Do the check-in and check-out evidence actually fully document the area? Is it not comparable? Am I not going to be able to support that there was actually a breach? Maybe you're making a claim for utility bills, but there were no meter readings. How are you going to support that claim if that evidence is not there? So have a really good think about that information within that check-in and check-out report, and have an honest comparison between the evidence to determine whether or not has there actually been a breach. And when you're doing this, make sure you're considering all of the relevant information. So I've got a couple of examples here just to show you. So this is taken from a check-in report that said in the text that the bedroom carpet had small wear and tear marks noted. What was also in the evidence file was a email sent to the landlord at the start of the tenancy with this photograph in there. The email was just saying, this is a photograph of the bedroom carpet. I just want you to know that the check-in report comments do not do the marks justice. And this is the photograph that they sent. So actually, if when we're looking at whether or not there has been a breach, maybe because you've seen this stain at checkout and think, well, I think we need to make a claim here for damage to the carpet, and you're just comparing that checkout photograph there with the comment in the original check-in report that said there was just small wear and tear marks noted, I mean, this to me would look like additional damage. I mean, I would think of a small wear and tear mark as something, fairly minor, whereas this clearly isn't minor damage. This is quite bad staining. So the first instinct there would be to make a claim that the tenant is in breach because they've damaged the carpet. But actually, if we looked a little bit deeper and looked at all of that information, we would know in our records that actually no, this stain was already there because the tenant reported this to us. Okay, and this is another example where we had a comment in the check-in report that recorded the double fridge freezer was new condition, free any damages or defects. But again, the photograph within the report here, actually this photograph in the actual check-in report itself as well, showed something that was quite different from what the comments were saying. This is actually showing that there are dents in here. This is going to bring into question for the adjudicator the reliability of that comment. I mean, this certainly wouldn't look like a new freezer to me. So really think about all of that information within that check-in report and in your case file there. And then finally, we've got this one, which is showing us a carpet, and the check-in report was just saying grey carpet, new condition. The photograph within the check-in report was telling us quite a different story. That just doesn't look like a new carpet to me. I'm sure you'd all agree. We've got some shading of the carpet here, and it looks like an area there just below the door where it looks like maybe there's been a rug or something sat there for quite some time, and slightly different colour of carpet there. So it certainly doesn't look like a brand new carpet to me. And the adjudicator is going to think about this. If it comes through to dispute, the adjudicator isn't going to just look at the comments within the report. They're also going to look at the photographs. They're going to look at any correspondence that the tenant sent. So, be honest with yourself at this point and looking at this and thinking, actually, has there been a breach? Has the tenant actually done anything wrong, or was this issue pre-existing? And then thinking about what happened during the tenancy. Give particular consideration to any repairs that you might have carried out during the course of the tenancy. That can help sort of build a picture. I mean, maybe you've carried out a repair to a leak during the tenancy, and at the end of the tenancy there's a bit of damage to a ceiling somewhere. I think we're actually going to come on and look at some photographs along those lines in a minute, actually, to illustrate that point. Actually, if you've carried out repairs during the tenancy, is that potentially linked? Also, did you replace something during the tenancy? Have you gone in and put new carpets down at some point during the course of the tenancy? In which case, make sure that you remember that that's been done and that you've got your invoices to support that, or your emails, your correspondence with the tenant referring back to that, because that's really, really relevant. I mean, the check-in report may be showing, slightly old carpets. Maybe they would have exceeded their lifespan by the end of the tenancy, but actually you've got evidence here to show that you put new carpets in during the tenancy. You want to be making sure that you're being fair to yourself as well when you're considering all of this information. Did you do any redecoration during the tenancy? Maybe the tenant raised some concerns about something. Maybe something wasn't working very well. A good example there of a case that I can remember is the tenant had reported issues with dining chairs at the start of the tenancy. Said that the spindles kept working loose, and these chairs kept falling apart, and he constantly had to keep repairing them, and could they be replaced? At the end of the tenancy, the landlord put a claim in for damage to dining room chairs. The checkout report showed these there was 3 chairs that had been completely dismantled. But actually, when you're reviewing that evidence alongside the correspondence from the tenant reporting issues with these chairs, actually, was there a breach? It seemed to me that maybe these chairs just weren't fit for purpose in the first place, and the issue was that they needed to be repaired. Okay, so make sure you are considering all of the relevant information as well. So this is, so I was just talking about a leak to the ceiling. So the checkout report here recorded that there was damage to the lounge ceiling, and you're thinking you might want to claim for repainting of the ceiling. However, when you look in the tenancy file, there's an email actually from a year ago in which the tenant reported that water was coming through the lounge ceiling, and the file also contained an invoice from the plumber for a repair to the bath waste pipe. I mean, a repair to the bath waste pipe, that's likely to be a landlord obligation. The tenant has clearly reported it. We've got the correspondence there from the tenant to show they reported it. There's nothing really to suggest that they did anything wrong. So whilst we've got damage, actually, it's unlikely that that's going to be the result of a breach by the tenant. So you're not going to be able to make a claim for that one. But we can contrast that with this scenario where actually, same example. So the checkout report recorded damage to the lounge ceiling, and you want to claim for the repainting of the ceiling. And actually, you've gone through all of the case file. Can't find any relevant correspondence in there. No damage noted in the interim inspection report that was only carried out 6 months ago. Bathroom's also above the lounge, so it seems like this water has been coming through the lounge. Doesn't seem like the tenant's reported anything. So actually think, actually, this seems to me like the tenant's done something wrong here. Even if it is a repair that would fall to the landlord, it seems that they haven't reported this to us, and this may have resulted in extra damage. So you get a plumber to come along and have a little look and see what's going on. And they confirm that there's no leaks and that the damage is likely to be the result of the bath overflowing. So you've got you've got the same damage for all intents and purposes here, but on one example we've looked at, actually there's not going to have been a breach because it's not anything that the tenant's done wrong, whereas in this example, yes, it does seem that the tenant's done something wrong. They've been letting the bath overflow, so there is potentially going to be a claim there. Okay, and then once we've had a little bit of a look at all of that evidence and established that there has been deterioration, we really need to be asking ourselves, hang on a minute, would this fall within the definition of fair wear and tear? And that definition is the reasonable use of the premises by the tenant and ordinary operation of natural forces. If something does fall within fair wear and tear, it's not something that can be claimed from the tenant. It doesn't represent a breach. They've just used the item in the manner that you would expect to use that item in during the tenancy. So you want to be thinking about things like how long was the tenancy? How many occupants did you have in that tenancy? What was the nature of the item and what was its ordinary use? So, a dining chair with maybe a padded seat on it that's got a bit indented during the course of the tenancy. Well, that's probably just happened from somebody sitting in it, eating their dinner. The weight of them has sort of flattened the cushion a little bit. But you could contrast that against, maybe the dining room chair seat being ripped, or maybe there's paint all over it or something. That's clearly a different issue. That goes beyond that ordinary use of the chair. So you're thinking about things like if it's gradual deterioration, it's probably the result of more normal use rather than because of a neglect or a breach by the tenant. I've got a few examples actually for us to look at, so we'll have a little look at those. So here we can see on the left-hand side of the screen, we've got what looks like a ceiling with a crack in it. It's like plaster settlement to me. That's probably happened gradually over time. It's not happened because of anything that the tenant's done. It's just where the building has settled, or the plaster settled a little bit. You can contrast that with the image on the right-hand side of the screen, which shows what looks like, shelves maybe have been ripped up off the wall, but certainly damaged. This isn't something that's happened over, gradually over a period of time. This seems like something that's, happened fairly suddenly, and that's the result of something that the tenant's done. So that would be an indication of damage that's been caused by misuse. Okay, so here we have a carpet with just some light shading to the centre, to the walkways. That's quite indicative of fair wear and tear. You're going to expect that carpets are going to be walked upon. It's going to cause some shading. You can contrast that with the photograph I showed you earlier with this big black stain on it. There's no way that's going to have happened through anything else other than misuse. Something's been spilt on the carpet, something's damaged the carpet, and that would be a breach. That's not something that's going to come within the definition of fair wear and tear. And then in this final slide, we can see on the left-hand side, just some slightly faded paintwork. It just looks a little bit dated, probably needs a bit of updating. That's going to be a fair wear and tear issue. That's going to be something that just falls to the landlord as part of their ongoing maintenance of their property, updating of their property. You can contrast that with the picture on the right-hand side, which appears to show some sort of soot damage to the ceiling, maybe through excessive candle burning or something. Whatever's caused it, you wouldn't expect that just to naturally occur through the normal everyday use of the property. It's more likely to be damaged caused by misuse. Okay, so that brings us to an end of today's session. I hope you've got a good idea from this session on how to be determining whether or not there has been a breach and whether or not it's worth pursuing a claim. We're going to come back and look a little bit further at this in our next session, where we're going to be looking at that second part of the test, the loss and whether or not a reasonable loss has been incurred. And that is also important because without both of those two elements of the test being satisfied, there will be no claim. So thank you for joining us today, and I will see you next time. Goodbye.